Hello, I'm Jack Hennigan, CEO of IRS Collections Canada. If you've listed your collection with us and received a recommendation for legal action from our legal team, you might find yourself with more questions than answers. Don't worry, this is perfectly normal. The goal of this presentation is to walk you through the key fundamentals of our legal department, outline the process, and set clear expectations so that you feel informed and confident on your action. So why litigation matters? Litigation can be a complex and intimidating process, especially if this is your first time pursuing legal action. However, for us, litigation is second nature. Our mission is to recover the maximum amount of money possible for our clients. And over the past 30 years, we've built one of the most practical, efficient, and knowledgeable legal teams in the country. With that in mind, let's dive into the process step by step. Firstly, and an important disclaimer here, I am not a lawyer, and this presentation is not providing legal advice in any way. However, at the time of your legal action, one of our licensed solicitors will review and sign off on your case at a reduced rate. This ensures your corporation meets insurance standards. Without this sign-off from a solicitor, you may face issues with commercial insurance down the road. So rest assured that will not be the case here. So let's cover the 6 key questions we generally get asked in our legal department. Here's what we'll cover. Why litigation is important? How do you start a claim? Do I have to appear in court? How long does the process take? How do I enforce my court order? And lastly, what will this cost me? So let's start with number 1. So why is litigation important? Litigation is often a necessary step in the collection process when debtors either refuse to pay or no reasonable repayment arrangements are being made on their behalf. Litigation is a positive. Why? It extends the limitation period of your debt. It starts the civil court process and provides an enforceable court order. It creates leverage by putting you ahead of other creditors, and it shows that you are serious. Debtors know you're committed to being paid and will pursue them. If you choose not to pursue litigation, that's entirely up to you. However, if you're serious about results, litigation is often a key part of the collection process. Number 2, how is a claim started? A claim officially begins once pleadings are filed with the court. However, before filing, preparation is critical. This groundwork determines the success of your claim. The key aspects to address before filing are ensuring the debt is worth pursuing, confirming that the debt is valid, verifying that all documentation is complete, and making sure the accounting is accurate. This is paramount to the legal action's success. So what we'll need from you is this: details of the debtor's business activity, which is generally provided to us when you first listed, copies of any contracts or agreements, whether these are written or verbal, details of any disputes or breaches of the contract, copies of all invoices and statements, and a full accounting ledger to confirm balances. Once we receive this, our legal team will draft and file the necessary documents on your behalf, all signed off by a registered solicitor. The last thing that we need from you in order to initiate your claim are 2 things. We require a signed permission to sue. That's right, you do need to sign and give us authorization to litigate on your behalf. We do also require from you a legal advance. The amount required of your legal advance will depend on the size of the claim and the province where the claim is filed. Your legal representative will outline these specifics to you at the time of requesting your permission to sue. Number 3, do I have to appear in court? Yes, you may be required to attend court appearances. While this is not common, it is possible depending on the defendant's response and the court's requirements. Good news, most hearings are conducted virtually, and when attendance is necessary, IRS Collections will provide a litigator at a discounted rate to represent you. Question 4, how long does this process take? We aim to exhaust all collection avenues before recommending litigation. Typically, our team needs 2 to 4 weeks to attempt resolution before pursuing legal action. Once you approve litigation, we require 7 to 14 days to draft and file the action on your behalf. Serving the parties takes generally another 7 to 14 days. Defendants usually have 2 to 3 weeks to respond to the claim depending on the province they're in. If no response is received, a default order is obtained and enforcement begins immediately. If a response is made, the court will schedule a date for resolution. So the sooner we receive your approval, the faster we can move forward with your claim. Point 5, how do I enforce my court order? Congratulations, you have obtained a court order. But what if the debtor still isn't paying? And this is where we at IRS Collections shine. Our legal team handles all logistics during enforcement, keeping you updated throughout the process. We work with law firms across Canada who trust us to enforce their court orders because of our speed, effectiveness, and results. When it comes to the enforcement process, you are in capable and safe hands. Leave that tricky business to us. If at any time you have questions, reach out to your legal representative, whether that be the legal assistant, paralegal, or the solicitor signing off on your file. And finally, what will this cost me? Yes, there are costs involved with litigation, but these costs are refunded once we collect. So how does this work? The first monies collected from your claim go directly toward reimbursing your legal investment. So let's say, for example, you invest $1,000. That amount is returned to you before any collection fees are deducted. A general cost breakdown here can be beneficial, so let's go through it. For small claims court, generally a cost would be $1,000 to $1,500 Canadian dollars to obtain a default order. Supreme Court can take you to $2,000 to $3,000. These costs include court filing fees, search fees, process serving costs, and any other legal fees involved. Enforcement costs vary based on the complexity of the case. A basic court filing can be anywhere from $100 to $200, where property liens can cost $500 to $800 depending on the province. Bailiff costs can vary and can start to increase depending on the geographical location and the complexity of the enforcement being made. These costs will always be outlined to you prior to any enforcement taking place. It is important to note here that most enforcement costs are recoverable and can be attached to the amount of your claim. So simple, right? There's no need to be overwhelmed. IRS Collections loves collecting money, and litigation is one of the most effective tools to get results. Our legal team, with hundreds of years of combined collections legal experience, is here to make the process seamless and stress-free for you. Let us handle the complexities so you can focus on what you do best, and that is billable hours. Thank you for listening, and I look forward to serving you.